that apply to mining technical disclosure. So we're talking about United States federal securities regulations, and specifically there are two main acts that you have to comply with when you register with the SEC and become a registrant, and that is the Securities Act of 1933 and the Exchange Act of 1934. And they have specific requirements for public companies that are have mining operations, mining properties, mineral properties, and they have specific standards, rules, guidance, policies around that. So if you're filing an annual information form, like a 10K, or if you're a foreign reporting issuer, you file a Form 20F. And if you're a Canadian company, subject to what's called the multi-jurisdictional disclosure system, you can take your Canadian annual information form you'd file in Canada and put a wrap on it and call it a Form 40F. And just to be clear, companies who file Form 40F from Canada coming down into the United States filing their documents don't have to do anything differently for SK-1300. So none of the rules in SK-1300 apply to the Canadian companies who are filing Form 40Fs with the SEC. If they're not subject to MJDS, they do have to comply with SK-1300. All non-Canadian, non-reporting companies that are registrants with the SEC have to follow SK-1300, and US-based, US incorporated public mining companies have to follow SK-1300. And that'll be for any of the forms they file, including 10Q, registration statements, current reports, and like I say, an annual report for foreign reporting issuers. So what is this regulation SK? You know, the SK-1300, so that is it's items 1300 to 1305 of this regulation SK. Well, it's a set of rules setting out detailed disclosure requirements. When you file a registration statement, like a prospectus, you go to the prospectus form, and it tells you for certain content in the prospectus, it'll refer you to regulation SK. Same thing when you do your annual report form under 10K or a Form 20F, it'll say, go to regulation SK, and if you're a mining issuer, a mining public company with mining properties, then you'll need to comply with, go to the property section 102, and then follow the rules there. So regulation SK is a set of rules setting out detailed disclosure requirements in forms and documents that you'd be filing with the SEC under both the Securities Act, which would be registration statements, and the Securities and Exchange Act, which would be these periodic reports, 10Ks, 10Qs, things like that. So if you go to regulation SK, they have these items, and if you go down to item 102 on description of property, this is for all companies, not just mining companies, but any company that has a physical property have to follow a description of content of things regarding that property. So if you're a mining property, under instruction 3, it says if you are engaged in mining operations, go to items 1300 to 1305. This is this SK-1300 rule, and follow it for your mining properties. So this is what directs you to items further down in the regulation SK, and there it has the specific content requirements for mining registrants. So here's the list of headings of the table of contents. When you go down to 1300, disclosure by registrants engaged in mining operations, and they have 1300, which are the definitions, and there's a series of specific definitions, many which are modeled under the Crisco family of codes for mining studies and mineral resources, mineral reserves, but I'll show you the list there. There's other things they put in there. There's a set of general instructions that apply to all disclosure, and you'll find that whether you're preparing a technical report summary or some description on your mineral property, there's a lot of general instructions you need to read and follow. When you get to 1302, it describes what a qualified person is. It describes the technical report summary and technical studies. These will be mining studies and other supporting studies that go into your pre-feas or feasibility study or a life of mine plan for your mining operations. Or in the case of mineral resources, you have to do a mining study called an initial assessment, which I'll describe a little later. If you have more than one mining property, and most companies do, they have to, in their annual report or in their registration statement under item 1303, they have to provide summary disclosure of all their mineral resources and reserves in a table form, and provide additional disclosure regarding their mineral properties. This is for the material and non-material properties combined. So if you have non-material properties, you still have to disclose any mineral resources or reserves you have. You have to have that information prepared by qualified persons. So it doesn't just apply to material properties. But when you go on to your material properties, that's under item 1304, you have to give individual property disclosure. Now, this is more detailed than what was required under the summary disclosure. So there's more detailed information in your resource reserve tables, more description about the ownership of the property and infrastructure and condition of the operating plant if you have an operating mine, other things that have to be provided under individual property disclosure. And the last item under this set of rules for companies, registrants engaged in mining operations is internal controls disclosure. And this is what the company's management team have the internal control over their operations, their mine operations, exploration properties, the process of mineral resource estimation and mineral reserve estimation. You have to describe this. Now, that's not in a lot of detail. I'll go through it very briefly at the end here. It appears to be focused on quality assurance, quality control on that process, but it's not meant to just be that, it's other things. So they replaced Industry Guide 7, which was the current policy document, the guide for companies with mining properties, with this SK-1300 rule. And their stated objective was when they published this new rule was to align the disclosure standards. So to do that, they did adopt standards similar to what's called the CRISCO-based codes. And CRISCO is a acronym that doesn't quite work because they changed the name of this group, but it's a volunteer group that has funding from industry and other funding sources that basically has representatives of mining jurisdictions, national standard setters in those jurisdictions. They work under this umbrella called CRISCO, Committee for Mineral Reserves International Reporting Standards, and they agree on a set of standard definitions, and they have a template that they published, and it was recently updated in 2019. And this gives a guide to any other countries that want to follow this harmonized definitions, terminology, reporting code, so that a feasibility study in one country is the same as a feasibility study on a mining property in another country, and your definition of proven reserves is aligned with what other countries would call that. And that makes it better for banks and mining analysts and investors to be able to understand the terminology, and that there isn't different levels of definition of terms and understanding of terms, that somebody's proven reserve somewhere else would only be considered probable or might only be actually inferred resource. You can't have that. It would harm the credibility of the terminology we use in the mining business. So they use the CRISCO classification of terminology for resources reserves. They use similar but not identical definitions for many of the terms, common industry terms. They allow the pre-feasibility study as the minimum study to determine reserves, whereas before it used to be what was called the final feasibility study for most reserves. In certain circumstances, if you were an operating mine and you had the developed operating mine and there was a satellite deposit to that developed mine, you were allowed to use a pre-feasibility study under the old Industry Guide 7. Now you can use pre-feasibility study to support reserves for any of your properties. You don't have to have a feasibility study. They allow now forecast metal prices, no longer the 3-year trailing average, which is again standard practice for most jurisdictions in the mining space. Will use forecast prices as opposed to some historical average. And they require this qualified person involvement. This is common. Competent persons under the JORC code in Australia, SAMREC in South Africa, the PERC code in Europe and the UK, all have this concept of having somebody with a degree in the specific to the mining industry, a certain amount of years of experience in applying that degree in the mining industry, and then relevant experience, and be a member of a professional association. So they bring professional standards, proper academic training, and ethical obligations under their professional association to the work practices they have. And that gives more credibility to the information, but also more consequences to the individuals who prepare this information, that if they get it wrong, they will have to answer to, of course, their employer and the company, but they'll answer to investors under securities legislation. They'll answer to the SEC mining staff who will be reviewing the documents, but they'll also maybe have to answer to their professional association to explain how they were doing professional practices, or were their ethical practices aligned with what they should be as enforced by the professional association. So the SEC liked this qualified person involvement, and they made that a part of this new SK-1300 rule. These are links where you can go to the SEC website. I presume the AIPG will be sharing this slide deck with the participants in this course. So you can go on there and you can see the adopting release that they put out when they first released SK-1300. It's about 450 pages long. There's about 400 pages of very interesting guidance from the SEC. When they took the comment letters that were generated when they put out the first draft, and they answered the comments that were provided by industry. And they got quite a few, I think it was over 80 comment letters. And there was a lot of very detailed, specific feedback they got from the industry. So they explained where they landed on their final rule. They answered some of the feedback on the comment letters and explained why they made changes to the rule, or in some cases didn't make any changes. And they gave some commentary around that. So it's a very good guidance document to get inside the heads of the mining staff of the SEC and see exactly what they were thinking about when they finalized the rule. So I would say that's a good go-to place for you. Go to the adopting release of SK-1300 and look for that document. They also have additional leaks. Well, there's the adopting release one. This one is I guess this is the actual published SK-1300 rule, the regulation SK. This is the adopting release, which is the one I find very useful to read. I read it several times. Periodically, every month, I'm going back to it and reading back again, well, what specifically did they say about that part of the rule? And you can get through to regulation SK through the corporate finance section through this link. And also they have this website for the various forms, 10K, 10Qs, 6Ks, 8Ks. You can read what they are, what the forms are, what they're used for through this link. Useful links. This is mostly historic now because we're now up here in late 2022, but they published back in 2017 the first draft of what became the regulation SK rule. They put it out for public comment, and then they revised the rule, finalized it based on the comments received and for further consideration. And they published that in October of 2018 and said it'll become effective in February of 2019. But they allowed a 2-year transition period of voluntary compliance. So you could voluntarily switch from Industry Guide 7 to this new SK-1300 rule up until 2021. I'm not aware of anybody who did that, but I was very aware of a lot of companies who took this time to get themselves geared up to be able to understand the rules and start preparing their technical report summaries, which they would then have to file. So when they filed their annual report in February of for the year of 2019, most companies still used Industry Guide 7, what they were filing under the old rule. And again, for their annual reports that they filed for the year of 2020, fiscal year 2020, when they filed those in February, March of 2021, most companies were still following Industry Guide 7. But once they got to January 1st, 2021, any registration statements they filed in 2021 forward had to follow SK-1300. And that's when we started to see companies like Nexus. They filed a registration statement, and they were some of the early filers of these first SK-1300 technical report summaries. But there was mandatory compliance now going on, but you were still, for many companies, were still operating under Industry Guide 7. if they weren't filing registration statements, but they were preparing their documents, getting ready to file at the completion of their fiscal year. So for companies with the December 31st year end, they were filing their reports in February, early March of 2022. And that's when we start seeing most companies now in their annual reports and exhibits to those annual reports, we're now filing their SK-1300 reports on the material properties and providing summary disclosure on all of their properties, material and non-material, using the new definitions, the new standards, and having qualified persons prepare all of their information. So this was the hard deadline. Now, companies that had an earlier fiscal year end, like a November 30th fiscal year end, they now are only just filing their SK-1300 tech reports because they're going at their year end is at the end of this month, November 30th. They have to file in January, early February of 2023. So you'll be seeing them. And when that happens, that's when Industry Guide 7 no longer applies. In fact, it no longer applies now. And everybody's doing everything under SK-1300. So that's where we are on the timeline. And presumably that's no surprise to anybody. So when you go into the SK-1300 rule again, it's not in items 1300 to 1305, you find the technical report summary requirement. It's actually under exhibits because all of the technical report summaries are filed as exhibits, as attachments either to a registration statement or to an annual report. So you go to the exhibits section, item 601 exhibits, and there you'll find under paragraph 96, it'll lay out all of the chapters, the 25 chapters of the technical report summary. It'll also tell you when they're triggered. It has a table there, which forms you file trigger technical report summaries. It also tells you when you need to provide consents if you're a qualified person or an expert that have provided tech report summaries, when those consents have to be filed with other filings and documents. So that's where you'll find all of this is under item 601. So at times now under the new SK-1300 rule, you will trigger tech report summaries because you will have a material mining property, and then you'll have to prepare your technical report summary, and it's as an exhibit, but it's also only for properties that have first-time disclosure of current mineral resources or reserves under the new SK-1300 rule. You may have had mineral resources, well, mineralized material under old Industry Guide 7, and you may have had reserves under Industry Guide 7, but the first time you file a annual report or registration statement using the new definitions under SK-1300, you will have to attach a technical report summary for your material properties. You should also have, for your non-material properties, a technical report summary in the background. You don't file it as an exhibit, but the SEC mining staff may ask you for that technical report summary for your non-material properties if you have mineral resources and mineral reserves. They'll want to see that if there's something in your filing, in your summary disclosure that they want more detail on, they'll say, please show as your technical report summary. It wasn't a material property, so you didn't file it on Edgar. You didn't file it as an exhibit, but you should have it in your files if you're going to be asked by the SEC. Not everybody seems to know that, but that's a policy the SEC staff have in place. Also, as you move on in the new rules of SK-1300, if you update your mineral resources or mineral reserves, and mineral reserves in some cases, and then you file an annual report or a registration statement, and those resources and reserves are materially changed from what was in your previously filed technical report summary, you will then have to file an updated technical report summary with these new changed mineral resources, mineral reserves, and all of the 25 chapters in the tech report summary will have to be updated. So those are your two main triggers, is when you first had to report under SK-1300 on your material properties. If you have resources and reserves, you'd be filing technical report summaries. If it's only an exploration property, you could file a tech report summary voluntarily, and then you'd be locked in. You'd have to update it every time you made a material change to your exploration information. You'd have to update your tech report summary with your annual report or any registration statements. Anyway, this is the very brief summary on the triggers. So these are when you go into the exhibits section 601, it gives you a table there and it tells you these are the different types of registration statements that says, do you need to file a tech report summary? Yes. So this is an initial public offering, a registration statement, a prospectus you'd file to become a registrant with the SEC for the first time. You'll have to have tech report summaries. If you are now a registrant with the SEC and you file an S3 registration statement or an S4, those will also be triggers for technical report summaries. Now, if you already have a tech report summary on file and you file a registration statement, if your technical report summary is current, you don't have to file another one. But if it's not current, if you've updated your resources reserves and that's materially different from what was in your tech report summary, you'll have to file a new technical report summary. A 6K, which is a current report for reporting any material information, or an 8K, this is for companies that file 10Ks and 10Qs, also a current report. They do not trigger tech report summaries. Same thing, quarterly reports, if you file a 10Q, any information in there, even if it's materially different from what was in your technical report summary on file, does not trigger a technical report summary. So there's no tick marks or X mark next to these types of filings when it comes to filing a technical report summary. 10K, this is your annual report. If you're a US-based registrant, that is a trigger. So you either, if you haven't got tech report summaries on file for your material properties, you'll have to file them if you have resources and reserves on those properties, or there's been a material change. 20F, this is for a reporting private issuer from outside of the US. You're not US based, you're not Canadian based, you're like Brazil for Vale, for Anglo-American, South Africa or UK, BHP Billiton, Rio Tinto, Australia-based, they file 20Fs, which is their annual report, and that triggers a tech report summary. 40F, these are for Canadian incorporated companies who are eligible for the multi-jurisdictional disclosure system. They don't have to file technical report summaries ever. They just file their 40F, and they follow the Canadian rules under 43-101, which are close enough to SK-1300. The SEC said there's no requirement for MJDS eligible Canadian companies to file anything differently under SK-1300. Just do what they always did. Any questions so far? I'm speaking quickly so I can get through my slides in the time we have, but I'll take a quick pause here. Any questions from the audience? You can write your questions down and take them at the end if you like. This isn't your last chance. Okay, nobody puts their hand up, so I'm moving on. So here we are. This is going down to the table of contents under item 1300 through 1305. If you are a registrant engaged in mining operations, that includes undeveloped mineral properties as well. That's considered mining operations. This is what you have to follow. So when you get to 1300, the definitions in alphabetical order, they give you these defined terms under SK-1300, and they have actual definitions. I haven't provided the definition here, but you'll see that, alphabetically, adequate geological evidence, conclusive geological evidence. You don't see this in the Crisco family of codes. You don't see this in 43-101. They define cutoff grade. Cutoff grade means a lot of things to different people. So the SEC wanted to be very clear on what they wanted to call that. They define different stages of registrants, whether the development stage and the properties that they have, whether they're development stage or production stage. They define what means economically viable, exploration results. They define the mineral resources, mineral reserves. They define the different mining studies, pre-feasibility, feasibility studies. They define qualified persons, relevant experience. So there's a lot of defined terms, some of which we see in other reporting codes, many of which we don't. Also, outside of item 1300, within the SK-1300 rules, you'll see some additional terms that have been defined within the rule. And then there are some terms that are used in the rule as if you should know what the definition is, but they don't provide to you any description of what that term actually means, but they use those terms and you'll have to figure out what that means for you in your context. And some terms are only defined within the tech report summary requirements. So you have to be careful. That list of defined terms I showed you is not everything. Here's those same terms now put by theme. So exploration results, exploration target. Mineral resource is a defined term, and material of economic interest is a defined term, and that's used within the defined term of mineral resource. Cutoff grade is a defined term, which is used in mineral resource. Inferred mineral resource, defined term. Limited geological evidence is a defined term within that definition. So same thing here under indicated, measured. You'll see modifying factors as a defined term. It's used in the definition of mineral reserve. In economically viable has the defined term investment and market assumption. So just be careful. You have to go and look at what the defined term means within some of these definitions. Initial assessment. This is a mining study at a conceptual level, similar to, but not identical to, a scoping study or a preliminary economic assessment under 43-101. But you need to have done an initial assessment for any mineral resources that you make public. For the material properties, you would then have that initial assessment summarized into a technical report summary. I'll go over that later on in my presentation. They define pre-feasibility study, and within that definition is a requirement for a preliminary market study. And that means you know you have done a study for the product from your mine, that you know there's a market for it and the terms and conditions for you to be able to sell into that market, and assumptions around the market price you would achieve. Now, this has more meaning for non-freely traded commodities. For gold, silver properties that are very freely traded, there's a ready market, and they're on commodity exchanges where you can get future contract prices, current prices, spot prices, and lots of information. You don't need a formal preliminary market study. But when you start getting into base metals where there is barriers to the market, like nickel, iron ore, even for some copper, lead, zinc, where the concentrate may have characteristics, lower grade, higher penalty metals, deleterious elements in it that require you to know, is there a market for this grade of concentrate with these particular qualities? Then you'll need a marketing study for your preliminary market study for your pre-feasibility study, and you'll need a final market study for your feasibility study. When you get into battery metals and specialty metals, rare earth elements, industrial minerals, where there is a close balance between supply and demand, and the quality of the product frequently dictates the price you would receive for it, you will need a market study to show there is a market to accept this production. If you're not already engaged in the market with an operating mine, but you're trying to develop a new project, a new deposit that has to find its market share and the market price you get for that. And there are market research firms that can do this, which is mostly what you'd be expecting to do for these specialty metals, battery metals. If you're an operating mining company and you're engaged in the market, you can probably do these studies yourself for base metals and where there's less barriers to market entry. And even junior companies that are not engaged in the market don't have to really do a study for precious metal deposits that are freely traded. They define different stages of the issuer and different stages of the property, and they use the term material, so you need to know what that means under the Securities Act and the Exchange Act. They define qualified person, and they define within that definition, they have the term relevant experience, which is also a defined term. So getting on to materiality, I do about 20 different slides on what is meant by material, material change, material information, material facts. I don't have time to do it under this presentation, but it's many rules in SK-1300 have no materiality test. You'll sometimes hear from accountants and lawyers, if it's not material, it's not important. When it comes to mining disclosure, we're one of those odd groups out where many of the rules have no materiality test. They are protecting the credibility of the information that goes out there. You can't have different people using different definitions of standard terms like what a reserve is or a feasibility study and come up with their own definition. So whether it's a material property or non-material, you must follow the definitions and only use those definitions in your public disclosure. So they protect credibility of the information, the integrity of the information, and they allow comparability. So you'll find many of the rules in SK-1300 have no materiality test. They apply to your non-material properties and your material. They apply to non-material disclosure and material disclosure. Moving on. They define what is a recognized professional organization. It's less prescriptive than what it is under 43-101 or under some of these other reporting codes. They don't have a list of professional organizations which are acceptable to the SEC, but they provide a detailed description of what they expect that professional organization, like AIPG, for example, needs to have in their bylaws. They need to have the ability to discipline their members if there's a complaint made about unprofessional or unethical practice. They need to require a public list of members in good standing so the SEC staff can go on and check to see that that person is indeed registered with this professional organization. And so they'll have to, if you are looking to see if the professional organization you're using to be a qualified person is acceptable to the SEC, you'll need to go onto their website to make sure there's a searchable list. I checked, AIPG has one for current members. But if you wrote the report 3 years ago and you're a current member and you're not a member now and the SEC reviews the report, you might receive a question from the SEC staff. So you might want to keep your membership current and valid through the life of that report. There is no independence requirement for qualified persons the way there are under 43-101 in Canada. The SEC considered independence would add to the compliance burdens, but you must identify whether the qualified person is an employee or has an ownership interest in the property, and that will allow investors to assess reliability of disclosure. But if you are not independent, that doesn't mean you can't be a qualified person. So there is no independence requirement to either author technical report summaries or prepare resource or reserve estimates or be the named qualified person in your client's disclosure or your employer's disclosure. There is no independence requirement. It's a Canadian thing. There are additional requirements that you must provide under the SK-1300 rules. Your basis for your metal price assumptions. You must provide a technical report summary for your material properties. There's a distinction between overall registrant obligations and property level disclosure. So certain things that you have to provide in general for the company in your annual reports, your registration statements, and specific detailed information for your material properties and even for your non-material properties. Obligation regarding disclosure, there's obligations if you do disclose exploration results, you have to follow certain rules. Mineral resources and reserves, all resources and reserves have to be based on work done by a qualified person, and you'll need an initial assessment report to support your mineral resources for your material and non-material properties. There are some allowances, as I said earlier in the presentation, they allow forecast commodity prices. You're no longer locked into 3-year trailing average, but you have to explain the basis of the time frame and how you determined what metal price you use. Industry consensus is a common basis used by most people now. Pre-feasibility study can support reserves. You can now disclose historical estimates of resources and reserves in the context only of a merger or acquisition, and there's some fairly tight rules around what you have to disclose. You can now disclose tons and grade of exploration targets. You could never do that under Industry Guide 7. You can now do it under SK-1300. There's some novel things in SK-1300 versus what was in Industry Guide 7. There are these core definitions, and they're generally aligned with the Prisco family of codes. I showed you a list of them. There's a maximum cost accuracy range for both your CapEx and operating costs for the initial assessment, pre-feasibility study, and feasibility study. And there's a maximum contingency that's allowed for those studies. Quite prescriptive. It was what the SEC regulators wanted to use as their lever to force better quality mining studies. And the one lever they could pull was the fact that they could state a maximum cost accuracy. So it's plus or minus 25% for a pre-feasibility study, a maximum 15% cost accuracy range for feasibility, maximum of a 10% contingency for feasibility, 15 for pre-fees. I have a table that shows these numbers. They require the market studies. I walked you through that. There's allowance for a qualified person to rely on and not be responsible for certain limited information provided by the registrant: legal information, environmental information, tax information. I have a list. I'll show you that. They don't allow disclaimers in the tech report summaries by the qualified persons. No content can be disclaimed. You must have either the registrant take responsibility for the chapter contents in the tech report summary or the qualified person. But there can be no content in there where you're relying on from some third party and then disclaiming responsibility. You're not allowed to do that the way you can under 43-101. They do allow consulting engineering firms to sign off on the qualified as an alternative to the qualified persons on the tech report summary and be named as who prepared that information. That's novel. You don't see that in Canada, but that was one way to make it a little easier for the qualified persons not to be directly named for reports prepared by consulting firms, not for reports that are prepared by your own company, mining company. You have to name the qualified persons and they have to sign the reports. You can't have your company, mining company, be the author of the report. They have to name their own qualified persons. Here's in the rule, you can identify a qualified person firm, a third-party firm comprising mining experts such as geologists and engineers. They're allowed to date and sign the tech report summary instead of without naming the qualified persons who prepared the report. In the background, the qualified persons have to be there. And if questioned, they need to name who those qualified persons are to the SEC mining staff, but they're not named in public. And that is to protect, it was one of the ways to get around the civil liability exposure to the qualified persons under the SEC rules. The US is a very litigious jurisdiction. Lots of people sue people, particularly experts. And there's a lot of things that go wrong in the mining business, and they didn't want to make that impossible for companies to find qualified persons to author their reports. So this was one of the ways they tried to make it a bit easier for those firms. So now I've got 10 minutes left, and I've got 19 slides. So I'm very briefly going to go through the tech report summary. It's modeled similar to 43-101. Here I have all the assets of a public mining company. They have a number of operating mines. The ones with red boxes are material properties. These ones down here are not developed, but they have resources and reserves, and 2 of them are material. And then these here are non-material properties, and here's a prospect without resources reserves. In the tech report summaries, you're going to need to prepare technical report summaries on all the properties that are both material and not material, but have resources and reserves. When it comes to your summary disclosure in your annual report or in your registration statement, you'll need to summarize all of your resources and reserves and information on your material and non-material properties under summary disclosure. When it comes to the individual property disclosure, that's for your material properties. It's only the ones that have resources and reserves and with red boxes around them. In this case, there are 4 operating mines and 2 projects. And then when you file your annual report or your registration statement, you will file as exhibits or attach as exhibits 1, 2, 3, 4 technical report summaries on your operating mines and 2 additional tech report summaries on your projects, which are not operating mines, but they're material, and retain in your files these other tech report summaries on your non-material properties that have resources and reserves. Hopefully that's clear to everybody, but at least there's a diagram that shows you that. So there's some things that they did in the tech report summary. There's no carve out for producing mining companies to omit the economic analysis, financial analysis if they have a developed mine. Under 43-101, you could do that, but under SK-1300, you can't. They don't allow this reliance on other experts provision under section 3 where you can disclaim responsibility. So if you take the table of contents from 43-101, which is on the right-hand side, and there's the table of contents for a technical report summary under SK-1300 on the left-hand side, you'll see very close alignment. They combined the geological setting and mineralization and deposit types into one chapter here, and they combined exploration and drilling into one chapter. Everything else has very similar headings, and if you look at the content requirements, they're nearly identical. Some issues in the economic analysis section, you'll see there'll be some specifics requirements, and under market studies, I told you about this market study, there's more detail required there. 43-101 has this reliance on other experts. What they have here under chapter 25 is reliance on information provided by the registrant, which allows you very similar allowance to what you get under 43-101. The difference is only the registrant can be responsible and not some outside third-party firm. When you rely on the registrant, it can be for macroeconomic trends, data, interest rates. This is the content you can rely as a qualified person for the registrant. Marketing information, legal matters, environmental matters, accommodations that are like impact benefit agreements you do to local indigenous groups or communities as part of your mine plans, and governmental factors that could be repatriation of profits, sharing of revenue, profits, other things like that. The governmental factors, the company, the registrant takes responsibility, and the QP can then rely on that. This initial assessment is a new study type. It's similar to a scoping study or a PEA, but basically it supports how you establish reasonable prospects of economic extraction. So here are the three study types. This is table 1 in item 1302 of regulation SK. And there's your initial assessment study. There's your pre-feasibility study and feasibility study and the columns across the top. And these are the factors. They tend to be modifying factors. And there are specific requirements for each level of study. But when I was saying the capital costs in an initial assessment, if you include them, you can have an accuracy range of plus or minus 50% for the initial assessment and a contingency as much as 25. But when you go to pre-fees, your maximum range is 25% on the capital and operating costs, and contingency maximum 15. And for your feasibility, plus or minus 15% capital operating cost range, maximum 10%. I'm finding this is difficult for companies to meet. There are some companies, consulting firms, who are taking their feasibility studies and downgrading them to pre-feasibility study. They still support reserves, but they feel they're better able to defend the level of study should they be challenged by the SEC, or worse, challenged by investors who say, hey, when you built this mine, you were outside of this very narrow accuracy range and contingency amount, and we're suing you. So they feel more comfortable to be calling them pre-feasibility studies, or what we do at Wood, we call them a minimum pre-feasibility level of study. Some components are done to feasibility, some are still at pre-feas, and one of the issues is the accuracy range and contingency amount. I'm not going to go through all the details there because I don't have time. They have a definition of economically viable. This is for reserves. It has to be a positive NPV. Used to be all it had to show was if you could make a buck on an undiscounted cash flow, it could be reserves. But under the new rule, it follows the rest of the world. You need a positive NPV supporting reserves in your economic analysis. I'm going to skip that. Here's the table example they want to show for resources, reserves for summary disclosure. That's the resources, that's the reserves. So they give you a table and say, you can use this table or modify it slightly if you like, but this is the kind of information we want to see. For individual property disclosure, similar table, but a little bit more detail for material properties, your mineral resources, and for reserves. There's additional content requirements in the rule itself. Won't go through that, don't have time for this presentation. And there are allowances where you can modify your table if it helps with your presentation. Internal disclosure controls, this is the last item I'm going to go through. And here's what it says is company registrant must describe their internal controls over exploration, mineral resource, reserve estimation, that it does include whatever you're doing for QA/QC, verification of analytical procedures, discussion of risks, but it's more than that. It's management's oversight of the process of exploration, resource estimation, reserve, any controls you put in place, sign-offs during key milestones. It's only a paragraph or two that they're looking for in the annual report, but behind that, you'll have a framework of corporate governance over your resource reserve estimation. And that's where I end. Didn't allow you the 10 minutes at the end for questions, but I'm hoping maybe I'm available if you want to talk for 10 or 15 minutes and go over anything I've discussed or any other questions you have. I've spent 3 or 4 years now on SK-1300, talked a lot with the SEC mining staff, prepared a lot of technical report summaries, been involved in panel discussions and short courses on this. So feel free, ask me anything and I'll do the best I can to answer any questions. Aaron?
Certainly, everyone, we can go a few minutes past the hour if need be. Greg, one of my questions to you is, we talked a little bit about competent or qualified person, and we talked about I saw you talk about the idea of a like a corporate qualified person. Could you, or a corporation that was qualified, could you expand on that a little bit, please?
Okay, so qualified persons are individuals because they have to have a degree and they have to have membership in the professional association and follow ethical standards, obligations and that. So it has to be an individual. But the SEC and the SK-1300 rule made an allowance that if you are a consulting firm made up of geologists and engineers or a combination of that, then the consulting firm, rather than the individual qualified persons, can sign off on the technical report summary. So they sign the signature page and they sign as Wood PLC, and rather than the individual qualified persons who contributed to the tech report summary. They also sign the consent that's required when you file that technical report summary initially. There is a consent that has to be filled out. It's signed by the consulting firm. And if there are later consents required when you file registration statements and other uses of that tech report summary, it's the consulting firm that signs the consents, not the individual QPs. That's a little bit more flexible for registrants if they're using outside consulting firms. But if they're preparing those tech report summaries by their own employees, staff, they can't do that. They have to have the individual qualified persons sign the reports, and those individuals as qualified persons sign the consents for the filing of the report and any future use. So hopefully that makes that clear to you.
Sure. And just as a quick follow-up, and then I see that Alan and Michael both have their hands up. Is there any indication yet of how that might impact liability in the case where mistakes are made?
Well, they're going to, in discovery, want to look who was responsible, who did you have prepare the information. And part of your due diligence defense under civil liability is you had appropriate professionally qualified people do it, following professional standards and all that. So those individuals are going to get drawn into it, but they won't be named individually. So they may not actually be named in the statement of claim when you file a class action lawsuit under securities laws, under federal regulations. You won't be naming the individuals. In Canada, you have to name the individual QPs, and in Canada, qualified persons have been sued under securities law, under the Securities Act, and resource estimators have been found liable for millions of dollars of damages to the investing public. But also the consulting firms get sued, the company gets sued, everybody gets sued. So they might get drawn in later, but they won't be named individually in the qualified. If they'll be drawn in during the discovery process, maybe, and they might get sued later. But it's one way of shielding the individual from having to have liability insurance. They'll let the company take the hit, and they will then defend themselves. And that qualified person may support the company, the consulting firm, in defending themselves to say why their feasibility study underestimated the capital cost estimates. And we know that never happens, but if that were happening and investors later sued because they way exceeded the capital cost estimate that was in the feasibility study when they built the mine, and now they feel as if the project isn't worth anything compared to what they thought, and the share price went down, they're going to go after whoever's responsible. Well, they'll go first after the consulting firm because they're the ones who are named as the author of the report. They won't be chasing the qualified persons in the statement of claim necessarily. They might try and draw them in to get evidence from them during discovery. Next question.
I see that both Alan and Michael have their hand up. We're just going to go with Alan first. Alan, if you have a question, go ahead.
Yes, Greg, we've spoken before, and in one of our previous conversations, we discussed the SK definition of measured resource, measured reserve, and the very strict aspect of that. Has any of that changed? Do you have to know the grade within a high level of certainty to classify an area as measured? I mean, geologically saying certain geologic certainty is an unusual term.
You have to have conclusive geological evidence, and that is a high definition. And also they use the top is there's other implications that you would only be able to get there with ore control sampling, grade control sampling just prior to mining for your short-term mine plans. So when we put it to, when I talked to the SEC mining staff about this, I said, was it your intention that measured would only be classified really when you had ore control drilling? You wouldn't really be doing it from drilling from surface or underground. You'd wait until you've actually exposed the deposit. In open pit, you would have blast hole data or ore control drilling ahead of your mining, your next few benches. Or in underground, you would have either close space drilling in tight cubbies underground, or also developing along the structure and the development on the mineralization. And they said, no, that's not what they're trying to do with the definition. That's not their expectation, is you would hold back on measured till only when you had that detailed sampling data. The problem is the definition uses this term conclusive geological evidence and terms like it confirms geological and grade continuity between points of observation. And to really, as a geologist and who has done resource estimation, I've worked in mines underground and open pit, I can't confirm geological and grade continuity until at best I have this ore control drilling. I'm always extrapolating, interpolating between holes. I know there's going to be some discontinuities, unrecognized faults or patches of discontinuous mineralization, but I'm generally interpreting it through from drill hole to drill hole for my mine planning, for my classification of resource. I don't really have that high confidence until I get ore control. And the SEC staff said, no, that wasn't their expectation. The problem is, if you later have a problem with your geological model and your resources supports reserves, and we see these with mining projects that have failed because when they went and developed underground and found the continuity wasn't there, lawsuits start flying, and the lawyers are going to look at the definition and say, did you really meet the definition of measured there? Did you confirm geological and grade continuity, have conclusive geological evidence? Or could there have been some, and as you later found out, some discontinuities and some unmineralized zones or breaks in your continuity of mineralization, which later upset your mine plan and caused higher costs and write-downs of reserves? And you're going to be hard to defend yourself using these definitions, in my view. And I know a number of resource estimators who won't go to measured because of that. They wait until ore control drilling before they'll go to measured. They, on anything that's based on drill holes, exploration drill holes, they'll only go to indicated. But that's not an SEC position that they were trying to drive people to. That's an unintended consequence.
Yeah, well.
Yeah, well, I mean, some banks want to have proven reserve for the payback period of the loan, for the finance that's being done. the question is whether some of this proven reserve really should have stayed in the probable category. And this is partially managing expectations and understandings of your investors, of the market, of banks. I think many of the measure that I see has still enough question marks on, and the SEC SK-1300 rule requires the qualified person to do their geostatistical analysis or whatever they do for classifying measured and indicated and inferred, and then do a second pass using the other geological uncertainties. And this can be sampling data, metallurgical test work, geotechnical information, even the ability to permit the project to develop a mine. If there's significant uncertainties there, then they say maybe you should downgrade your measured to indicated, or maybe even your indicated to inferred. And the same thing, we've always had that from when you have uncertainties regarding your modifying factors, you could downgrade what would have been measured instead of going to proven, you would go to probable. So we've always had that concept in the Crisco family of codes. Well, the SEC wants you to apply that as a resource estimator. So after you've done any statistical classification, drill hole spacing, minimum number of samples, minimum number of sample drill holes, they want you to do a second pass with all other geological uncertainties and see if you need to downgrade your established classification to something less than that. And you basically have to confirm in your tech report summary, you've done that. And your final classification is what you're showing, factoring in those other uncertainties. And again, this is where you get into trouble in civil court. If you're sued, if your measure didn't really turn out to be measured, and you found there's pinching and swelling or intersecting mineralized structures that are critical to the better grades and better thicknesses that you didn't recognize early on, and now only later through more drilling and maybe exposing the deposit through mining, you recognize them, and you're in court saying, well, you said you understood those geological uncertainties, including the ore controls on the mineralization, and you had confirmed that with conclusive geological evidence, and sure looks like you didn't have that, then you're responsible for misleading the public, and that was unprofessional, yada, yada. So this is the risk that people are a little bit concerned about, is these definitions are pretty tight. They're tighter than what you have under the Crisco family of codes for measured. But the SEC mining staff said they didn't really intend to drive people to downgrade all the measured to indicated. That was not the intention.
Yeah, the problem is there's a disconnect here with the banks, because as you know, when you're going out for investment and you're looking for investors, they very quickly want to look at the ratios of things measured, indicated, and inferred. And if you don't have any measured, you immediately start to get overlooked by the banking community because of your,
a risk discount to your
I know, but there's a slight disconnect here between what the SEC intended and what the banks are seeing. So what can we do about it? There you go. You know,
well, you're not going to get the SEC to change their rules in a long time. I've already pointed out they've got a few errors in SK-1300 and some misinterpretations, and I pointed those out, and I said, will you at least inform the public about that? And they said no. I said, well, you change the rule? No. So there we go.
Well, I think we have time maybe for one more question. I'd like to let Michael Feinstein have the opportunity to ask his question. Michael, go ahead. You are muted, Michael, if you're attempting to ask a question. If not,
okie dokie. Can you hear me now?
Absolutely.
Okay, great. Thanks, Greg. That was a good summation, and I'll definitely probably follow up later. I guess had a couple of quick questions. So between 43-101 and the SK-1300, there's a different signing kind of procedure where we would certainly want to put it under our LLC or whatever firm was responsible for the sections, and then we have individual named parties as kind of a subset under that on the signing page. And I'll just kind of look at some precedent for, I guess, clarification on that. But then also the initial mineral resource, so I guess one of the big differences is, we've got add a bit of a scoping study to opposed to just element in the ground as had a little bit been allowed in 43101. And all of that is generally just kind of at the discretion of the QP. And of course, you know, our density of drill data and everything else is going to vary based on deposit style and everything else. But I guess I just wanted to get your input on that. You know, how detailed a level of engineering study is necessary for just kind of putting that initial mineral resource. And I guess it is kind of a full scale kind of scoping study of the deposit and taking a mining concept into.
Well, they want you to consider capital costs. You don't have, so your capital costs have to be considered. You don't need to include your stated capital costs in the initial assessment report. You can if you want to. And if you do, they have to be no more than plus or minus 50% accuracy range and no more than a 35% contingency. But you do have to look at the same modifying factors that you would apply to reserves. You have to apply that to resources, mineral resources, but you do it conceptually rather than by quantitatively and doing it within a pre-feas. You're doing it in a conceptual level study, a scoping level study. But you do have to know your process method, your mining method. You have to know what your mining costs and process costs are within a certain broad accuracy range. And you have to have the basis of your cutoffs that you apply to those mineral resources. You need to establish your basis for reasonable prospects of economic extraction. So yes, you do have to have some engineering input, but it's really, you can borrow, you can use analog deposits, you can use information and factor and scale it from other, you don't have to build it up from a zero base the way you might do in a pre-feas or a feasibility study. And there's definitely a lot less engineering definition, but there will be some design, some limited to support the basis of your cutoffs and reasonable prospects. And you'd have to have a critical mass of enough to pay back your capital. So so these are all things that they want to see in the
so you must be able to run like some real hard conceptual models, but not necessarily like going through full pit designs and stuff like that.
Yeah, and that's, again, you wouldn't necessarily have an engineered pit with all the ramps and access and getting all of the sharp corners and bends out. You will have to have some geotechnical data to support your assumptions, either for your pit slopes or for the dilution and mine losses you may be applying in your scenario for the appropriate underground method, whether it's more selective or more bulk mining, mass mining. You would have some limited geotechnical data to support that.
Okay, that is cool, great. I mean, I might have to give you a call to chat about that in more detail or shoot you an email. Thank you, Greg.
The other thing is, if you have reserves, you must have resources. You're only allowed to disclose resources exclusive of reserves, but the SEC feel you would always have resources as a starting point, and there would be some resources left behind when you converted your measured and indicated to proven and probable. If you don't report resources, we've seen the comment letters, they will ask you, how is that? Explain to us how that is. So that's another specific that the SEC are saying, you can't get away with not reporting mineral resources if you have reserves.
All right, one more question. I see Michael Neumann from over in Germany has joined us. Michael, you are ready to ask a question.
Yes, hello, Greg. Thanks for your presentations, was quite helpful. I have the case where I'm working for a client here in Europe. They have two historic mines which are accessible, which do have, difficult to say, resources, but not compliant to any Frisco code, the old East German and Russian codes. Now, the client wants to go in the United States for an IPO, and we are preparing, because we can't prepare a pre-feasibility or anything better, but because we don't have samples, physical samples, they are on paper, the old samples are lost. What we want to do is an exploration target report. But if I see your presentation, probably we can do an initial assessment report as well. Would that be possible?
No, you're not going to get to mineral resources without your own direct sampling and verification of historical sampling. So if you can't show QA/QC how you verified the legacy drilling, legacy sampling, that it's suitable to support resource estimates, you won't even be able to get to inferred resource. And the SEC,
Not even, no.
So you'll need to do some method of whether you do twin hole drilling or you say it's old operating mines, if you can resample areas that there was, you have the old resource models of whatever system they were using, and you have been able to verify grades and somehow establish maybe at least to the inferred confidence level, but you're going to have to do some verification sampling and do data verification on that legacy drilling to get SEC SK-1300 standard of mineral resources. You said you could do an exploration target. I would say that's your first port of call, is try for your exploration target, because then you have a basis for the tonnage and grade range from the historical mining and the non-compliant reporting codes. SEC doesn't accept any foreign codes at all. You have to use their codes only. The fact that you may be using a JORC code or a 43101 CIM definition, that's okay, as long as you say this is what it is under SK-1300. But you can't take a Russian code or a Chinese or a UN code or something else and say, well, here's this, and we think this is representative of. You have to demonstrate how you converted it, and you also have to show you have the basis of the reliability of the sampling and all that. So I would say you could go to exploration target. You are allowed to do it under SK-1300. Tonnage and grade range, cautionary statements stating the basis of the magnitude of the tonnage and on the grade that you have. And that grade range should be reasonable, meaning it should be within the range of what you were seeing for the historical mining. So that's probably your first chance to do that, and then talk about how you're going to establish resources by verifying legacy drilling and maybe do some twin hole drilling and stuff like that. That would be my suggestion as path of least resistance.
Thank you.
Well, I hate to cut the discussion off. Greg has given us a lot of his time. I think it's been phenomenally informative, Greg. I would love to invite you back again sometime in the future, or maybe a year from now, and we can maybe have another update. But until then, I really want to thank you for a fantastic webinar.
Well, thanks very much. Sorry for the bit of a late start. I would have allowed more questions at the end here. Yeah, I'm monitoring the comment letters from the SEC, and so you're now being able to see specific feedback they're giving to industry on particular rules in the context of those companies' projects. So there will be probably more to update. I mean, I could have gone on. I do a 16-hour seminar, a webinar presentation on SK-1300. I'll be doing one in Reno, Nevada in December at AEMA. I'll be doing another one in February in Denver at the SME. So those are live. I'll be standing there live. I have a colleague of mine, Stella Searston. The two of us, we've written dozens now of SK-1300 reports. We reviewed many reports, and we've spent many, many hours with the SEC mining staff getting clarity on a whole range of issues. But there is a lot to say. There's a lot of devil in the detail. I try to give you a very high level, but I'm welcome to be invited back next year, and I'll try and start right on time next time.
That'll be fine. I really do appreciate it. And
well, the questions are really good. To me, it makes it very interesting for me too to hear what people's questions are, and it allows me to elaborate on some of the content I went over. So we really need to allow that. But to try and get through the whole rule, I mean, there's so much to try and cover in a summary version. There you go. I had to speak quickly. You may have noticed.
I really appreciate it. Thank you very much, folks. Thanks everyone for coming. Before you go, make sure you put your request for CEUs in the chat. We will get you a certificate if you need one. I thank you all for attending. Greg, thank you. Everyone have a wonderful day.